Everyone, and welcome to this short video. This is Jones Chase's A to Z of employment law, and today I'm dealing with the letter D, which is about data subject access requests. So firstly, looking at a summary of the rights. So an employee has the right to make a subject access request. This means an employee can ask their employer, or even a company affiliated with their employer, for information on whether or not personal data is being processed about them. If the employee's personal data is being processed, the employee is entitled to be given a copy of that personal data together with the purpose of the processing, categories of personal data concerned, the recipients or categories of recipients to whom the data has been or will be disclosed, and along with other information. Processing is defined in the General Data Protection Regulations, otherwise known as GDPR, as operation or a set of operations performed on personal data, such as the collection, recording, and storage of data, as well as various other actions, which I will not list in this video. So now looking at an employer's response to a request. So the employer should deal with the data subject access request without undue delay, and in any event within 1 month of receipt of the request. Although this may be extended to 3 months considering the complexity and number of requests. In this context, dealing with the request may involve an initial assessment by the employer considering, firstly, whether or not they process data concerning the employee, the scope of the request, how they intend to find the employee's personal data, which may involve conversations with your IT team, whether or not they intend to respond, and if so, can they respond within the 1 month time limit. Responding to a subject access request can be time-consuming and expensive. In the employment setting, access requests are frequently made in the context of a grievance or ongoing internal dispute or a tribunal or court claim. An employee may be genuinely motivated by a wish to find out what data is being processed about them and make sure that it is accurate. However, an employee may also see the time and the expense to which an employer may be put to in replying, and it can offer useful leverage in a dispute in achieving a settlement. It can also be used as a method for getting preemptive disclosure in a potential dispute. Whatever the motive, an employer must be ready to respond. So now looking at what the required contents for supplying information to the employees are. So when the employer receives a request, they must ensure that the request comes from the person who is making it. This can be dealt with by a passport or driver's license, for example. Where the employer has reasonable doubts over the identity of the individual making the request, they can seek additional information. The timescale previously mentioned, 1 month to reply, does not begin until information requested to verify identity has been completed. Now looking at exemptions to providing subject access. So where a subject access request relates to personal data in respect of the following, the employer is exempt from providing it. Firstly, documents which are protected by legal privilege. Secondly, personal or household activity not in a work context. Thirdly, a reference given or to be given for employment, training, or educational purposes. Fourthly, personal data processed for the purposes of business management or planning. And fifth and finally, personal records of intentions in relation to negotiations between the employee and the employer. There are other exemptions that I have not mentioned, but if an exemption is relevant, that personal data should be redacted if there are other parts of the same document that are part of the request, or otherwise removed if the whole document falls within the exemption. Finally, looking at 3 top tips for employers in collating information to respond to a subject access request. Firstly, use sensible IT search terms and clearly evidence how you completed the searches after the employee makes a request. Secondly, make sure you scrutinize each document to determine if it is subject to an exemption or not. And third and finally, personal information relating to another individual should not be disclosed unless that individual has consented or it is reasonable to disclose the information to the employee without the consent of the individual. If you have any questions or would like to discuss the areas I've talked about, please contact the Jones Chase team on 0203 837 9914 or visit joneschase.com. We would love to help you, and I hope you have enjoyed this video.